let's jump right into this meticulously detailed explainer of an absolutely landmark Supreme Court case. We're looking at the 1976 clash between the Commissioner of Wealth Tax and the late R. Sridharan, along with the companion case involving his wife, Rosa. If you're deep into taxation or family law, you already know this is a cornerstone case. It perfectly illustrates that incredibly fascinating and sometimes messy intersection where personal law, secular marriage, and the tax code all collide. To make this crystal clear for your notes, we're going to break the whole thing down using an enhanced IRAC method. We'll run through the factual timeline, isolate the core legal issue, look at the statutes involved, weigh the competing arguments, and finally, unpack the court's step-by-step reasoning and ultimate judgment. Starting with Section 1, the facts of the case, let's map out the exact sequence of events that kicked off this whole legal battle. So our story begins with R. Sridharan. He is a Hindu man, part of a Hindu undivided family, and he holds ancestral property. He ends up marrying Rosa Maria Steinbecker, who is an Austrian Christian. Because they're from different faiths, they do the standard thing and marry in a secular ceremony under the Special Marriage Act of 1954. Shortly after, they have a son. Well, when tax season rolls around, Sridharan files his wealth tax returns claiming Hindu undivided family, or HUF status. He's arguing that his ancestral property should be taxed as family property rather than as his own individual personal wealth. And this is where the conflict ignites. The wealth tax officer flat out rejected this filing. The officer's logic? He argued that because this was an interfaith marriage performed under a secular act, the family could literally no longer be considered a Hindu family. The core of his rejection was the claim that a son born to a non-Hindu mother simply couldn't be a Hindu himself, and therefore, no way could he be a co-partner in the family property. That brings us right to Section 2, defining the family unit and the core legal issue. The Supreme Court had to answer this very specific question. Can a Hindu who marries a non-Hindu under the Special Marriage Act and has a child actually still be assessed as an HUF for wealth tax? Ultimately, they had to decide if the son from this secular union was legally a Hindu who could inherit co-pursuatory rights to his father's ancestral property. Now, I know you guys know this, but let's just quickly anchor our understanding of a Hindu undivided family. An HUF is a joint family of all persons lineally descended from a common ancestor, assessed as a single legal unit for tax purposes. Maintaining this status was the whole ballgame for Sridharan, because, as we know, being taxed as an HUF often brings some highly beneficial tax implications compared to individual assessment. You also really have to keep the definition of a co-partner in mind here. A co-partner is someone who acquires a legal right to ancestral property strictly by birth under Hindu law. This is the absolute linchpin of the case. If Sridharan's son didn't get this right the second he was born, there's no joint family. That entire HUF tax structure Sridharan was relying on would completely fall apart. Okay, Section 3, the rules and statutes. The real headache in this case comes from the fact that the court had to interpret 3 totally different legislative acts at the exact same time. It's like a giant legal puzzle. You've got the Wealth Tax Act of 1957, which dictates how an HUF is actually assessed. Then you throw in the Special Marriage Act of 1954, specifically Section 21, which says succession to property for anyone married under this act is governed by the Indian Succession Act. And finally, you have the Hindu Marriage and Succession Acts, which provide the actual legal definition of who even qualifies as a Hindu. The court had to perfectly balance tax law against secular marriage rules and personal succession definitions. So looking at those Hindu Marriage and Succession Acts, this quote is the absolute key. It defines a Hindu to include any person born of parents where only one is a Hindu, provided they are brought up as a member of the tribe, community, group, or family. Notice that. The heavy focus is entirely on how the child is raised, rather than requiring strict two-parent religious lineage. Moving to Section 4, let's look at the actual debate between the revenue and the assessee. The revenue came out swinging. They argued that using the secular Special Marriage Act completely severed the family's Hindu character. They claimed a non-Hindu mother meant the kid couldn't be a co-partner, and that Section 21 basically deleted Hindu personal law from the equation. But Sridharan held his ground. He countered that he never once renounced his religion, and importantly, his son was being raised as a Hindu. Because of that, his son automatically gets an interest in the ancestral property by birth, keeping that joint family status totally intact. This brings us to Section 5, the court's reasoning, and it's so interesting to see how the Supreme Court completely dismantled the revenues argument. First up, the court established a firm baseline. Using the Special Marriage Act does not automatically strip a Hindu spouse of their religion. There is literally no provision in that act mandating an automatic conversion. Sridharan was Hindu before the wedding, and he remained legally Hindu after it. The validity of the secular marriage is an entirely separate issue from the religious identity of the child. Following that exact logic, the court laid out a very straightforward three-step conclusion. Step 1. The father remains legally a Hindu. Step 2. As a matter of established fact, the son is brought up as a Hindu. Step 3. Therefore, referring back to that expansive definition we looked at earlier, the son legally qualified as a Hindu from the exact moment he was born. Then the court addressed the coparcenary issue, and this part is a real game changer. They made a brilliant distinction between mitaxara law and Section 21 of the Special Marriage Act. Under the mitaxara system, a son's right to his father's ancestral property is acquired strictly by birth. But Section 21, that governs succession, which is inheritance after death. The court basically said, look, rules about what happens after someone dies absolutely cannot erase a son's pre-existing right by birth. The revenue had completely mixed up the timing of these two distinct legal concepts. And that brings us to Section 6, the final judgment. Boom! The court unequivocally rules in favor of Sridharan. His HUF status for wealth tax was fully upheld. The income and wealth from that ancestral property had to be assessed as a family unit, not just pinned on Sridharan individually. This set a massive precedent. It legally established that an interfaith marriage under a secular act does not destroy the HUF status of ancestral property just as long as the kids are factually raised within the Hindu faith.